Got it. Good morning. This is Senate Judiciary. It's Wednesday, March 9th, 2022, and we're in a hybrid where many of the witnesses and some members of the committee are in the committee room, and some members of the committee and witnesses are not in the committee room and they're on Zoom. So we're doing the hybrid system and see how it works. So our first witness today is Matt Valerio, our Defender General. And Matt, why don't you take it away? And then we'll hear from Judge Zone and then get down to the markup of the bill.
Thank you, Matt Valerio, Defender General. And a brief ability to talk about this last week. And some of the questions that have arisen since then are, what are the facts about particular cases that have been, and Senator Sears, you were asking yesterday, that have been overturned, and what I have tried to do is get a sampling of those. I am interested in, I was interested in the pie charts. I know the Department of Corrections is renowned for its graphs and charts, and me much less so. But in looking at the numbers that we have from January of 21 through the beginning of March of 22, we're talking about 76 cases that were dealt with or pending in the courts. And interestingly enough to me, the vast majority of the total number were affirmed, but you have about 8% that were reversed and 13% that were settled. Those are STIPs, as they call them. And early on in the process, the department was not settling these cases when they came to them. But I am told by prisoners' rights that of late, after kind of getting an understanding of what the court is seeing in these cases, many more of them are being settled. I have provided Peggy with a summary of the testimony that I'm going to give you, and some of this analysis, we talked about the cost savings that have been incurred by the Department of Corrections in the state of Vermont as a result of the reduction in these interrupts. Now, remember, these interrupts are for technical violations where there would be an interrupt of more than 90 days, okay? So not new crimes. And by virtue, one of the things that obviously Justice Reinvestment 2 was looking at was the ability to reinvest. By our calculation, and you can see this at some point, I don't know if it's posted yet because I barely got this. Okay, but thank you. Is that almost $800,000 in incarceration costs have been saved by the reversals of the interrupts that we've seen so far. But what I wanted to do primarily is talk about some of the cases that have come before the judges and some of the decisions that have resulted in reversal. There is, and I go by the client's initials as opposed to putting their names out there in the public, which is something very common. If if for some reason somebody needs actual names for some reason, I can give those. But let's look at the VC case, and I'm basically going to go. Excuse me.
It's on the sheet.
Just trying to find your document.
It just says written testimony from, I just wanted to get up there quickly. I can change the name, but it's, if you refresh your screen, it should be there.
Go ahead, Matt.
Okay. I'm basically going to be going down the case specifics. Under the VC case, this is one of the cases that there was a written decision on. The Department of Corrections gave VC a 4-year interrupt in prison for texting with a person to be known as Bridget, quote unquote, for violation of his furlough agreement. Bridget and VC had known each other for 18 years. And in this particular case, Bridget first texted VC, the inmate. VC is intellectually limited. He refers to Bridget as his quote unquote support person. In 2010, she was a victim in an unlawful mischief case that he was involved in. As part of the agreement, VC was not allowed to have contact with Bridget while he was on furlough. However, when he was in jail, Bridget was allowed to have phone contact with him and did so regularly. Oh, geez, I sent you the wrong thing.
Oh, all right.
So you're looking for, I can send you the right one. That's the, you can have that, I guess, but that's kind of my summary. That I sent you the wrong one. They're very similarly named because it's about the same bill. Nevertheless, I will be getting to that. In any event, so when he was on furlough, Bridget texts him. He responds to her, and after considering the facts, I mean, remember, this is a 4-year interrupt. The court immediately ordered DOC to release VC. So this is one of those things where if it went through as proposed, the proportionality of the response, a 4-year additional time in prison for texting with somebody who the person was allowed to have contact with while in prison via telephone, and a person who is of limited intellectual capacity, seems to me it's a disproportionate response to what I personally see as a minor infraction, and the court felt the same way and saw that as an abuse of discretion. And part of this abuse of discretion issue is the proportionality of the response to the offense that, or the violation that might have occurred, violation or violations that might have occurred. The JB case is another one. And this is a case that where you're looking at a proportional response and you're looking at that sort of thing. Some of these cases kind of lay bare the difficulties that poor Vermonters face and how much harder it is on those circumstances when they are on furlough. JB suffers from a persistent depressive disorder. He recently lost 3 relatives. He stopped taking his medication and he relapsed. JB was supposed to sleep at an approved residence, but sometimes he stayed at his pregnant girlfriend's house so he could care for her mother. Her mother had a kidney disease, a broken and infected leg. JB would sleep over so he could carry the mother-in-law to the bathroom when she needed to go. And when he didn't stay there overnight, he would come in the morning and have to clean up because the poor mother was incompetent and unable to get to the bathroom on her own. The court wrote in the decision, and I'm quoting, "Although it was heavy and distasteful work, it made JB feel needed and useful to be able to help his girlfriend's sick mother. During this period, JB missed several phone appointments, with his furlough officer. JB was obviously afraid to go back to prison, so he disobeyed his furlough officer's orders to report to probation and parole in person. Eventually, JB was arrested at the home, and DC gave him a 1-year sanction. It is, and this I'm quoting the court's decision. In its decision, the court noted JB's fears proved to be true due to his arrest and the 1-year interrupt. He missed the birth of his child, and his girlfriend's mother is now in a nursing home. In that case, the court ordered his immediate release. And so you can see the contrast between cases where, where we win them or where, prisoners' rights wins them, the clients win them, and ones that we don't. There's a case SA, and in this case, prisoners' right lost that case, and the court was willing to uphold DOC sanctions when those sanctions are reasonable. In the case of SA, a court held a 1-year sanction given to a man who had absconded for 7 weeks and was found in another part of the state by police who arrested him. In contrast, in the case of DM, the courts were not willing to impose a long prison sanction for somebody who, quote unquote, absconded by missing appointments and are later located and arrested on a DOC warrant in their home where they're supposed to be. So sometimes the word abscond is a little bit vague, and it could mean missing appointments as opposed to going anywhere. Where somebody was, basically left the area where he was supposed to be and was found for 7 weeks and was found in a different spot. The court said, no, we'll support the sanction. In the case where appointments were missed, and then he's arrested exactly in the place where he was supposed to be, the court said, no, that's not a fair response. There's the case of TH. TH received a 1-year interrupt for missing a single phone check-in. The judge reduced it to time served, and that ended up being 9 months because that's how long it took to get the case into the court system. It would have been shorter, but for that delay. There's a case of CW, a person who broke curfew twice during the same day and then ended up coming back. It was a daytime curfew that he broke, and then he ended up coming back. He missed a meeting with the probation officer. CW had recently moved to emergency housing that was over an hour from the probation and parole office, and this was with the provision of probation and parole, but lacked transportation. She communicated continually with the PO about this. When she missed the meeting, the first she'd missed since moving farther away from the P&P office, she was FSU was sent to arrest her rather than to give her a ride back to P&P or allow her to report to a nearer P&P office. The sanction was a 2-year sanction. The court reduced that to a 1-year sanction. These are some of the examples of the types of cases that get reversed. And to me, when you're looking at the issue of abuse of discretion, abuse of discretion is defined in the statute in this particular case. With that, we kind of negotiated this, and I remember very specifically with Commissioner Baker. Now, obviously, the Department of Corrections has the ability to change its mind with different commissioners and different different years and the like. But this has basically been in place for 1 year, and that standard of review is not something, Commissioner Demmel talked about it as being almost like a confusing or misleading sort of thing. In fact, the standard of review is very similar to what we have had in the past in both appeals from small claims courts to Superior Court and appeals from probate courts to Superior Court. So you might lose in front of a small claims judge or lose in front of an elected probate court judge, something you're litigating there. Then you have the ability to appeal that to Superior Court on the record. And in some instances, and particularly probate court, and because I remember doing one of these, you have the ability to bring the record that you had below, and then ask the court for the ability to bring in other witnesses if you want to supplement whatever record was there. That was very important in these types of cases, more so even than in small claims or in probate court, because in those two types of cases, you have the right to a lawyer, but in a furlough interrupt, the client, an inmate, doesn't have the right to a lawyer, and they don't know exactly what to present. And I don't know that it necessarily make a difference with the Department of Corrections, because they clearly look at things differently than the court has in some of these cases. But this is not a confusing standard. This is actually relatively simple. You get whatever record is below. The defendant gets to say whatever it is he or she wants to say. And if the court deems it appropriate, they ask for or allow other evidence to come in. These hearings last an hour or less on the whole. And I understand, by the way, the concern the department has regarding the record issues on cases that clearly on their face do not meet the statutory requirements for review. And Commissioner and I talked about that. We agreed on that, that there should be the ability for the department to say, we're certifying that this is not a interrupt that is greater than 90 days. And as a result, it doesn't even meet the jurisdictional standard, subject matter jurisdiction, to be able to have this in court. And I understand as well the court's concern about these cases being all lumped on one judge. It is not uncommon to have cases obviously brought in Washington County, because the Prisoners' Rights Office is in Washington County, the Department of Corrections is in Washington County, and that's the typical place where you would bring them. To me, it doesn't matter. These hearings are done via video. We won't be sending people all over the state for the most part, to be doing these cases. I would imagine there might be the outlying case where some additional evidence has to come in, and the person needs to be live in Bennington or Wyndham or something like that. But for the most part, that's not going to be the issue. So the venue issue is not really a problem with me. To me, I think the court on the venue issue should be able to assign it to wherever they would like to. It really shouldn't be either the Prisoners' Rights Office or the Department of Corrections, quote unquote, judge shopping or looking for a particular place to put these cases to try to obtain a result. That regarding the assignment of cases, if they're filed in Washington County, but they would need to be doled out to a judge in a different county, that is no problem for us. To me, the biggest issue is the changes in the standard under Rule 74. If the standard is changed from what it is now, and as suggested by the department, this effectively eliminates review in these cases. It really does. I mean, this is for the period of time from the Douglas administration, when furlough came into place, until the change last year, the decisions of the Department of Corrections regarding furlough were unreviewable, short of decisions on furlough being made for an improper purpose, like somebody's race or religion or sexual orientation or something like that. The decision of the department regarding furlough was unreviewable. And if you can't take into account the length of the furlough interrupt, that is the proportionality of the sanction based upon the degree of the violation, then you aren't really balancing anything, and you are putting the department in the exact position they were in for the last decade plus of having their decisions be effectively unreviewable. Now, part of this with Justice Reinvestment 2 was about looking at the 80% of people who were being reincarcerated, being reincarcerated based upon technical violations. And do we really need to do that? And did we really need to change the public safety paradigm by doing that? And we've been through that ad nauseum, but we also need to remember something else that this came out of. This came out of the troubles that the Department of Corrections was having at the women's facility and other facilities, where furlough was being used as a tool and a stick to coerce people into doing things that they didn't want to do. We've heard things about, and if we remember the article that came out in 7 days regarding, the issues regarding sexual favors, the issues regarding drugs and the like, with individuals on furlough and their ability to, they felt they had no recourse regarding that sort of thing because one individual had an unreviewable right to terminate their furlough. And even if that information, if brought forward, might have made a difference, the perception to the inmates and to those who might be inclined to do that sort of thing in the department was that their decisions were unreviewable. And when it came to furlough, so I think what we have here is I don't see this as broken in any way. If what you have is the court reversing, what was it? I have too many screens going here.
Half the cases.
Half that come before it, but out of the total, you're talking about review by the court, 8%.
So if I understand correctly, your concern is not with on page 2, lines 13, number 3, the appeals, where they're here, the venue is not an issue. Is that correct? So where your concern is are you concerned with number 2 on page 2, which is the lengths will not be a consideration in the abuse of determination? Is that or is it the de novo review? Where are the biggest concerns?
Those two portions are the biggest concerns for me, because changing that standard of review, and if you can't consider length, then you aren't considering proportionality of response to minor violations. And if you change the de novo review, and all you're doing is saying, we're going to take the record from below and we're going to have a court look at it anew, and the defendant again can say whatever they want to say, and if the court wants more evidence, they take it. Remember, these are short hearings; these are not long hearings that occur. They set up 3 or 4 of them in a day at times. And
so in the case, I'm trying to understand this, Matt. So in the case of VC, that's the kid that, JB, the kid who was helping his pregnant girlfriend's mother. The court would not be able to look at the full record, nor would they be able to look at the length of the interrupt. Is that correct?
Well, they wouldn't be able to look at the length of interrupt, and they wouldn't be able to, and there would be immediate deference given to the department regarding abuse of discretion. So that's what the balance is.
I think I'm better understanding your objections now. Uh, Other questions for Matt on this? Pretty,
I will send you this, I will send you the portion that I intended to send, as
okay,
opposed to my, the other part.
no problem. I actually have it. You sent that to me, and I was actually reading it yesterday, and I think I understand your objections. I mean, the case, but I understand that I don't understand why the department opposes having the court look at the length of the interrupt, if I'm understanding what this would do.
You know, this is one of the things, and I remember clearly Commissioner Baker saying, we want the court to look at this. We want somebody, we want to be transparent. We want to make sure that the decisions we're making are appropriate. And, you know, we haven't even gone a year. We basically went a year. One of the things I obviously chide the legislature over on occasion is you don't let anything percolate long enough. You know, we'll do something, and then if we get bumps in the road, it immediately gets changed. I don't see this thing going off the rails here with the numbers that we're talking about. You know, the Prisoners' Rights Office isn't complaining about the number of cases they're getting. We haven't asked for more money or more people or more staff or anything like that. You know, the one thing that we are seeing a little bit lately that is of a little bit concern more is that we get people violated for furlough interrupts when they are cited for new crimes, but then the new crimes are never charged. So you end up somebody getting a citation, probable cause isn't even found. It's just, you know, and some of the ones, you know, the charges are never brought. So the interrupt ends up being the equivalent of getting a criminal conviction. So I'm, you know, the last part that I kind of wanted to bring up, and I know you understand the heart of this, but is that last portion about, you know, the arrest warrant. To me, the issue really has to be, for me, somebody needs that. You can't just be cited for a new crime and then incarcerated for 4 years on an interrupt, and then no charges ever be brought. I mean, there's something not right there. Nevertheless, you get the core understanding of what I'm talking about.
I think I do. I wonder if there's other committee members. Senator Baruth. I can barely see Senator, and I thought she was putting her hand up. So go ahead, Senator Baruth.
I'm wondering, I echo your confusion about why the Department of Corrections would oppose looking at the length. And I'm sure Commissioner Demmel must have covered that at some point, but I'm wondering if he might, when he responds, just address that directly.
Did anybody have any other questions of Matt? Because I think he was fairly clear. I appreciate the examples, and I appreciate that you used initials, so we're not, some of us may be familiar with the individual, and it's not helpful to pass laws based upon one individual. I didn't recognize any of them. But you did tell me that Vern was one of them by mistake.
Yeah, I noticed it after, but
well, I had a resident one time who we nicknamed Vern, and but it wasn't him. Anyway, why don't we hear from Judge Zone quickly if he has any not quickly, take your time you need. I didn't mean to say quickly, Judge.
Okay.
God, I don't want you to make decisions quickly. I want you to have them thoughtful.
Thank you. So good morning, Tom Zone, Chief Superior Judge. The new bill, we agree on page 2 with the venue. Absolutely. That language meets what we believe would be appropriate. As I said last time I testified on this issue, the word policy is the word that really comes to mind. And Senator Sears is addressing this issue, and others are talking. Senator Bruce mentioned it too about, do you want the legislature, do you want the judges to have the ability to address the length of the interrupt? That's a policy decision. In looking at when you're making that policy decision, I thought it might be helpful to give you an idea of what's actually happening in the cases. In other words, how did the judge look at that when they're applying this? A judge doesn't just say, well, you know, I don't think that's appropriate. I'm going to just do X, Y, or Z. The judge, under the statute as it exists and as it's proposed, would have to find an abuse of discretion. And the CW case that Mr. Valerio talked about, the judge actually talks about this. The judge writes, while DOC clearly has discretion with regard to the length of a furlough interruption, its exercise of that discretion must be tied to the criteria identified in section 724D2. Equally, any exercise of discretion under this statute or otherwise must not be arbitrary and capricious. The judge goes on to write, to avoid characterization as arbitrary and capricious, any exercise of discretion under this consideration must be informed by some sense of proportionality, both to the nature of the violations and to the context in which DOC imposes a consequence for those violations. The judge went on to write on the specific facts of that case. Here, without in any way minimizing the importance of strict compliance with conditions of furlough, the court observes that none of CW's violations presented any threat to others or threat to abscond. Indeed, they appear far more technical than the criminal conduct that led DOC to impose a 6-month interruption of her last furlough. Recognizing that some escalation of response is warranted by the continuing pattern of technical violations that occurred here, the court concludes that 2 years is clearly excessive. Instead, a 1-year interruption is more proportional to both the nature of the violations and the disciplinary history against which they have occurred. And so I point this out because when the judges are looking at the length, it's tied back into the factors that the legislature has already identified. As far as the Washington County cases, I'm aware that the judge sitting in Washington County has issued 24 written decisions. Out of those 24 written decisions, in 13 of those decisions, the judge has affirmed the decision by the Department of Corrections. In 9 of those decisions, the judge has reversed. And 2 of those were ones I believe that Mr. Valerio mentioned today. And so it's the court's view that this is a policy decision. If it's going to be a situation where the legislature says, no, we don't want you to get into the length of the interrupt, it will significantly alter what judges are doing under the existing statute, and it will significantly limit the scope of review. But that's a determination for the legislature to make. I'd be happy to answer any questions.
Well, I'm gonna give you a strange scenario, because if I were DOC and I were a officer in the field and I had this person who was continually behaving in a way that was not appropriate, although he did not commit a new crime, and I knew that if I suggested a violation to, I think they'd go through the central office, but if I was to consider a furlough interrupt, and I knew that the court could change it, I might be more likely to go longer than otherwise, taking my chances in court. The other thing is, I believe that the central office still is the party, and I can be corrected on that. But if you're making a decision to furlough a prisoner and you're taking a risk because this person may or may not do well, you might err on the side of caution if you know that you're going to end up in court if he screws up a little bit or a lot, and you could have that taken away. So I'm trying to balance both of those factors, but because I would agree with you that our decision to allow the courts to make decisions regarding interrupt. And the length of that interrupt was to try to avoid those types of situations. But human nature being the way it is, you're less likely to take a risk if you're afraid that you might get overturned.
Well, as far as the first scenario you indicate about the officer in the field asking for something more because they think it might get knocked down, it would certainly be my hope that the Department of Corrections and its employees, in imposing any type of furlough interrupt, would be imposing one that is based upon the specific facts and what is necessary and right in that case, without regard to preparation for a possible appeal and the idea that it might be knocked down. The goal is to do justice. And so on that one, I think that really falls on DOC to do, if you will, the right thing initially.
Well,
as far as the cautious.
Well, I would only say, Judge, that in my scenario number one, if the person was was charged and the state attorney is looking for a plea deal, they usually charge higher than what they expect to get. And we all know that. So I'm not sure that, the behavior of DOC would be much different.
Well, that's a different situation because in those circumstances, the court would not be imposing a sentence if the state was asking for something higher. The court would not be imposing a sentence based upon finding an abuse of discretion. The state would come in and ask what it wants. The defense would come in and ask what they want, and the court would have to weigh the evidence and consider the facts under the law to determine what is the appropriate sentence. The appeal under 724 does not allow the court to have a wide open analysis. It still is, as the judge wrote in CW, it still has to go back to abuse of discretion. So there is deference to the Department of Corrections. And the question is, how is that deference analyzed? And the second question you asked, Senator Sears, about when the decisions are made, and sometimes you have to make them based upon concern or caution, if you will, for what could happen. That's also happening with the judges under the 724 analysis when they find the abuse of discretion, because they're balancing what is the appropriate length of the interrupt, because the judge's goal is the same as DOC, I would hope, and that is you want to have an appropriate sanction that protects the public in a way that does justice for that individual, society, and follows the statute.
Is there the next question has to do with page 1, line 17, where the bill strikes, the appeal shall be based on a de novo review of the record. And the appellant may offer testimony, and in discretion for good cause shown, the court may accept additional evidence to supplement the record. Is there somewhere in between de novo and what the department has recommended? Not being an attorney, I'm just looking for help here.
Well, what's written in the current statute is that, as Mr. Valerio talked about, judges can say, we want to hear additional information. If it's an appeal solely on the record, you only are going to get what DOC has. And so if there's information that may be relevant and material, you're not going to get that. And so having that additional ability of the judge does allow the judge to look at something different. And the oddity, if you will, is that you're looking at different facts. So when we look at it and say, well, you're overturning DOC. Well, yes, you're overturning the DOC determination, but the statute as it's currently written allows you to have additional evidence. So it's not apples to apples. The judge may be looking at an apple and DOC looked at an orange.
Okay. Understood. I guess I'm just looking for something in between. What's in the record often doesn't tell us everything we ought to know. Yeah, I don't, if I look at that Matt or the Defender General brought JB up, I'm not sure the officer knew all that. The officer who recommended the interrupt and the furlough knew everything that is contained in Matt's analysis of the case. He probably should have, but we don't know. No, well, thank you, Judge. Is there any questions for Judge Zone? Maybe it would be an opportunity for the commissioner to comment on where his view of this. I guess we all agree on number 3 on the venue.
Yeah, good morning, Senator Sears and committee members. Thank you for having me. Nick Demmel, Commissioner of Corrections for the state of Vermont. Appreciate very much the conversation today. I think we're getting to the crux of a lot of the issues we're all facing here. I think on the de novo question, just because it was the last thing that we covered, I would point back to the court decision that we highlighted the quotation in our presentation yesterday, because I think the court points out the problem that it's facing. On the one hand, you're saying you need to decide whether the department abused its discretion, but at the same time, you're saying, and you can consider information not available to the department. Those standards can't coexist, in my opinion. And I do think that the records are actually much more robust than maybe we're giving them credit for, and that much of this information is contained therein. As it related to the cases that the Defender General outlined, he captures much of what is going on there. But I think that there are key facts that are missing from some of that presentation. And that is the pattern of behavior that led to the final determination, which resulted in the interruptions. And so the department could go line by line with you through those cases and explain the additional backstory if that's useful, or we can provide supplemental information that can outline how the evaluation by the department was not a single event, but is captured in a pattern of activity that results in them moving down the severity of the grid, which leads to greater interruptions. But I think what I'd love to spend just a minute on is really discussing the idea about whether the court should be able to review the length of the interruption as it in its discretion, in its determination. I agree completely with Judge Zone. I think he makes a great point that ultimately this is a policy decision for the Senate Judiciary Committee and your other legislative committees to decide. Whatever you decide, the department can live with that, and we will be sure to implement that guidance. And if the decision is that the court should be able to determine through an abusive discretion standard that the department abused its discretion in giving a long interrupt, and they want to change that, and that was the policy decision of this body, then certainly we will support that. But I want it to be very clear what that policy question is that you are answering. The determination of the length that the department uses derives directly from our work with CSG and through the Justice Reinvestment Initiative. That process developed out a grid that is an evidence-based standard that is objective, that we measure all of these cases, the records and the facts against, to determine what length of sentence we should give. So if you decide as a body that the policy should be that courts have the right to change the length of the interruption, what you are in fact doing is departing from that grid pattern and introducing the court's subjectivity into the process. And so where we worked with CSG and tried to institute policies that would move us to an objective standard based in evidence to determine lengths of sentences for interruption, we would then be reverting backwards and now introducing subjectivity into that same process. If that's the determination, certainly we can live with that. But what I wanted to be clear, and this was also highlighted in that same court decision, is what you are asking is for this, and this is a quotation from the court decision, you'd be asking for the Supreme Court to simply substitute its judgment for that of the department and usurp the power delegated to the executive branch. Right now, that power is to use the objective grid crafted in concert with CSG. And what we would be replacing it with is the determination of the court. And so you will necessarily introduce disparity across the state. It's okay if that's the direction we want to go. We can support that. But I wanted to be very clear. That's why the department was asking for you not to allow the courts to look at the length of the interrupt so that we can remain true and sincere to the JRI process and the grid that came out of the CSG work. I saw Senator Bruce raise his hand.
Yeah, Senator Bruce.
I'm just struck, Commissioner, by your sort of blind faith in what you're calling an objective grid. I'd prefer not to live in a society where my fate is determined by an objective grid. I think a grid, as you are pointing to it, is a tool, and as an instrument, it's a blunt instrument. It's an attempt to make logical shape out of inchoate details and evidence. I feel much better at the end of the day having a judge take a look at an individual sentence when it reaches his or her desk and apply their judgment. You're talking about an objective grid and a subjective judge, and the grid was produced by people. It is also subjective in its own way. So, I understand the point about wanting to follow the data, and I think Justice Reinvestment 1 and 2 were successful in part because they followed data. But I will say that not having the judge be able to look at the length of the interrupt strikes me as, a kind of faith in that grid that I can't muster.
Certainly, Senator, I think I fully understand your point, and it's a valid one. And ultimately, that's the decision I think that's left to the Judiciary Committee to make a determination on. What I will say, though, is while generally I agree with you that we don't want to live in kind of a myopic world where we're constantly evaluated against grids and there is no human aspect, no subjectivity to it. When we didn't have this grid, we had huge numbers of interruptions. Since we introduced this evidence-based approach, we have seen a precipitous drop in the number of short interrupts. And I think ultimately the department has been really, really effective at weeding out who are the individuals who do need longer interruptions as a public policy matter and who do not, who can be safely in our communities.
And I wasn't arguing to get rid of the grid. I would be arguing to use the grid and then correct it against the judgment of a judge. So I haven't yet heard an argument, a compelling argument for why the judge should be forbidden to look at the length of the interrupt.
And that's fair. And ultimately, I think that's up to the committee. And I don't want to pressure you one way or the other on that. Ultimately, that's your public policy determination to make.
Did I see a question or a comment from Senator Benning?
Well, you
Again.
may have seen something coming out of my ears, Senator Sears, but I hadn't raised my hand, but I'll take this opportunity. Commissioner, I'm going to just point out, as a defense attorney, my trust is in the judge who actually sentenced my client when reviewing what is going on with my client within corrections. Much more than I would I'm going to call it a red tape response inside the facility to what the facility may be feeling they're aggrieved about. But at the end of the day, it has always been the judge, not the Department of Corrections, who has sentenced my client and understood initially what it was my client did wrong and what the state's expectation was through the judicial system for that client to have some form of rehabilitation or punishment or whatever the case may be. But I've recently had a situation where I got very frustrated that my client was lodged. Judge Mello issued a decision instructing the department to release him forthwith. And for some reason or other, several days went by before corrections decided to follow through. And I do not, to this day, understand what the rationale was behind that. But it's kind of upsetting that the department simply took a position that it was going to do what it wanted to do. And I'm going to agree with my colleague from Chittenden at the end of the day that I would much rather have the judge making the decision.
Yeah, again, I certainly respect and appreciate that position. And then in that case, I would certainly agree with Judge Zone that it reverts back to if you make the determination that the courts should be looking at the length of the sentence, the interruption, then it would revert back to the court to use the abuse of discretion standard to do that. And the courts have demonstrated an ability to use that standard in that way. As it relates to your specific case that you raised, I'm not familiar with those fact patterns, Senator, but certainly I'd welcome the opportunity to talk with you outside of the committee about that and make sure that either what we did is clear to you so that you can have faith in our system, or if something went wrong, that we certainly address that, because we are continually interested in improving and ensuring that our standards are being met. So thank you for raising that, sir.
One other question, and I guess it's based upon knowing some people. How do we avoid the frivolous, somebody's interrupted for a year. It's legitimate. There's no real argument. But they're in Springfield, they have little to do, so they might as well see if they can get that reduced to 6 months. And that kind of takes up court time, takes up prisoners' rights time, if they're even involved, takes up DOC time. How do we deal with that type of scenario?
Well, Senator, I think in that instance, if the individual who is making the appeal meets the criteria under the law, ultimately it would go to the court to decide that then. If they don't meet the criteria, and this is one of the reasons that we think that the certification language in this bill is so critical, we could dispose with that by filing a motion saying that they don't meet the basic standards set out by the law. But if they did meet the standards, then I think it would be left to the court's discretion to make that determination.
Where exactly do you do that in this bill?
So the certification piece begins on page 1, line 19. And covers onto the next page through line 6. But really that's focused on making sure that the individual who's filing an appeal under Rule 74 meets the basic criteria. In your circumstance, I think the fact pattern that you outlined, they would meet the criteria because they would have an interrupt over 90 days. It would be for whatever the violation is. And they're simply looking to say the department abused its discretion because my sentence is too long. In that circumstance, it wouldn't be filtered out by the certification process. That would go to court, and it would be left to the court to make that determination.
Okay, so Ben, can I ask you a question? I realize I'm interrupting the commissioner. I apologize for that. Ben, what the heck's in between the complete review on these types of cases and what the commissioner is recommending here in section C1?
Sure. Yes, I'm Ben Wodrowski from the Office of Legislative Counsel for the record. There are a few standards of review. That's what we're kind of discussing. And, the abuse of discretion standard, which has been discussed, the de novo standard, which has been discussed. There is a clear error standard or clearly erroneous that kind of is somewhere in between. It does provide a level of deference. And I should have to say, though, that the way that the statute is written now is sort of a hybrid in the sense that it's de novo plus additional evidence. But the clear error standard does provide deference on issues of facts to typically trial court review decisions. So that could provide a level of discretion that's somewhere in between the extreme deference of an abuse of discretion standard and sort of reviewing the case anew under the de novo standard.
Thanks. Matt, did you want to comment on that? Thank you, Ben. That's helpful.
There were two pieces about this that I felt were important to remind the committee about. And to get to your question of the frivolous cases, the frivolous cases are those that don't meet the criteria at all to even be in court. And I think that that is something that we agree with the department on. And clearly we can save them significant effort in compiling records on cases that are, have interrupts of less than 90 days, for example. However, there's a difference between a frivolous case and a case that might not be a winner. We deal in public defense, 95% of our cases are cases that might not be a winner. So we're used to dealing with those on a regular basis, and I don't think you're really going to get rid of those. One of the things I think is important to remember regarding this standard of review that we have now is that below, where they're having their administrative hearing and the decision is made by the Department of Corrections, those clients do not have lawyers. So they don't have the ability to be advised as to what evidence they should bring forward, what they should say, what they should do. And they clearly do not have a trust in the Department of Corrections for them to do the right thing. The reason this is the way it is it gives the defendant a voice, number one, with counsel, sure that if there was something that was missed below, that evidence is brought before a judge. These are not involved hearings. They, as I said, they take less than an hour. But where you have individuals who do not have the right to counsel creating a record below, they need to, in my view, and I think it was what the legislature decided just last year, they need to be able to have a voice going forward, unless the interrupt was less than 90 days. And actually, I had proposed, and I said this to Baker last year, that maybe it should be a 6-month interrupt, not a 90-day. And he says, no, 90 days is appropriate. He was.
Why was I just going to ask Ben to prepare a rewrite would be 180, 6 months, 180 days.
As a practical matter, we can't get him into court very much sooner than that anyway.
Okay. Well, are there other questions on this before we move on to our break and then another bill? What I'd like to do, Ben, is if you could come back tomorrow with a redraft to make it 180 days so that the interrupt of any time before 180 days would not be reviewed. And the venue we've all agreed with. And then we're down to a couple of issues, and we can debate them and decide whether we want to move forward. So it's not a complete new draft, it's just some idea. And also, I kind of like to see your middle ground on the de novo review.
Okay. Yeah, I can absolutely prepare those in the new draft and incorporate the clear error standard if you'd like, just so it's something to look at on paper, and then can be subject to debate.
Why don't we schedule that for 11 a.m. tomorrow morning? Would that be okay?
Okay.
Any other?
So do you want to do, sorry.
What, Peggy?
So do you just want to do the right to farm bill from 11 to 12? Because Michael Grady's not available at 9.
Well, I'm sorry. Can we talk about this after
Sure.
we let go on?
Sure.
And long as Ben is available, that's no.
I'm available all morning, so.
Okay, cool. All right. So Matt, did you have a final comment, or your just hand is up?
Yeah, I did. I just wanted to make sure, and the commissioner and I had agreed on this, that that the department would not have to produce a record if the case didn't meet whatever the minimum time standard was. They could just file a document that says this interrupt does not meet the minimum time standard of section 724 and certify to it. That was the other piece that I think, and so just to help ledge counsel, if clean that up.
That's that language starting on page 1, line 19, just for your awareness, senators.
Okay. Thank you. I think we may not end up getting to where everybody wanted to be, but I think we can at least get something to move forward with that doesn't satisfy anyone completely, but at least gives people some new direction. Okay.